um, start off by just letting you know what the plan is. First of all, if anyone has any questions along the way or comments, please feel free to use the raise hand option that's available on Zoom, or you could put a message. You could direct message me in the chat, or you could try to raise your hand on the screen if your video is on. Nancy, you win for the best background. I hope for your sake you're where it looks like you are, but for my sake, I'm jealous if you are. Okay, so that's in terms of if anyone wants to ask any questions or make any comments. We're going to be having a multimedia presentation tonight where we'll be looking, watching and listening to some videos of Ruth Bader Ginsburg, as well as looking at some texts from her and from other people and Torah texts to talk about dissent. We may know that Justice Ginsburg was very well known for her dissent. She spent a large part of her time on the Supreme Court in a minority, and so she ended up writing lots of dissents. So just as a way just to get started, just for some background information on Justice Ginsburg. So Ruth Bader Ginsburg was born on March 15th, 1933 in Brooklyn, New York. She was the second daughter of Celia Amster and Nathan Bader, and they lived in Flatbush. Ruth Bader Ginsburg's father, was an immigrant from Odessa, the Ukraine, and her mother was born in New York, and her mother's parents, her grandparents, came from Krakow, Poland. Her sister, Marilyn, the eldest daughter, died of meningitis when she was 6, when Ruth was 14 months old. That's just her early life. The family belonged to the East Midwood Jewish Center, which is a conservative synagogue, and that's where Justice Ginsburg learned her aspects of Judaism and Hebrew. She attended Jewish summer camp as well, and including being a counselor until she was 18 years old. She went to Cornell University, and that's where she met her husband, Martin Ginsburg. She was 17. She graduated from Cornell with a Bachelor of Arts in Government, and then she went on to enroll in Harvard. And then after Harvard, when her husband took a job in New York, he was also in Harvard at the time, she transferred to Columbia Law School. We'll get a little bit of more of her personal background as the class goes on, but I'd like to now move on to sharing my screen, and we could get to the actual sources and the material. Okay, so this here we have the okay, so as you're calling this RBG on RBG, and I do want to let you know that since her passing, I haven't been able to sleep because I feel a tremendous amount of pressure now being the only other RBG, and I have to bear all of that on my shoulders. So I appreciate your support as I go forward with that. So we're going to talk about dissent in law and halacha, and we are going to begin with a video of Ruth Bader Ginsburg herself talking about the importance of dissent. We'll get a definition of dissent, a legal definition of dissent as well, but we're going to start with listening to her in her own words about the importance of dissent. So here we go. I want to make sure you could hear her. Can you hear? No. Okay, hold on. Let's try this now.
Some losers can be turned into winners. I can give you some examples. We all try our best, but sometimes the court gets it wrong, sometimes egregiously so. One such case was from the late 1970s, when school teachers were being forced out of the classroom. The minute their pregnancy showed, they were put on what was euphemistically called maternity leave, which was unpaid, and you had no guaranteed right to return. Well, the Supreme Court had a case involving our principal anti-discrimination in employment law, Title VII. It says no discrimination on the basis of sex. Came to the conclusion that discrimination on the basis of pregnancy is not discrimination on the basis of sex, because the world was divided into two kinds of people. Non-pregnant people included men as well as women. And then there were the pregnant people. They were only women, but on the basis of sex, no. There was a groundswell of opposition from both sides of the aisle. And in short order, Congress passed the Pregnancy Discrimination Act, which said, it was the soul of simplicity, discrimination on the basis of pregnancy is discrimination on the basis of sex. Think of probably the worst case the court, worst opinion it ever issued in the Dred Scott case, where the then Chief Justice said, no person brought to the United States from Africa in chains will ever become a citizen of the United States, and no descendant of such a person. There were two dissents in that case. The dissenting position is today certainly the law of the land, or the free speech cases around the time of the First World War, when there were two dissenters, Holmes and Brandeis. Those dissenting positions are now the prevailing view, the prevailing interpretation of the Constitution. So you can be writing a dissent to get Congress to make a change, or to affect a later court that will see the error that its predecessor made. Many losses turn out either immediately or in the long run to be winners. So every time I write a dissent, I'm hoping for one result, either congressional change or the other, that the court will overrule its prior wrong decision. Who is it who said that it ain't over till it's over?
Okay, so hopefully you could still hear me. Yes, okay, great. So it's interesting that what she said is remarkably close to the idea of dissent in halakha, and the reason why in the Talmud and in legal cases, the dissenting opinion, which is not the law, is cited. It's actually, on one hand, a very frustrating thing for people who are learning Talmud. They want to get to the bottom line. So why do I have to go through hearing all the argumentation of a case, of a position that ultimately gets rejected? What's the point? I just need to know. Just take a classic example. I just need to know if I light one candle on the first night of Hanukkah, or I light 8 candles on the first night of Hanukkah. Do I light one and go up, or 8 and go down? But nonetheless, the Talmud, in that case, and in thousands and thousands of others, tells us the dissenting opinion. And we're going to look at some literature to explain why. But first, we'll talk about what is dissent in terms of the Supreme Court. So we have here that the Supreme Court decides a case, they issue a majority opinion. The majority opinion explains why the majority of justices decided the case as they did. However, in many rulings, not all the justices agree and that the decision was correct. In this case, one or more justices will file a dissent that comes along with the majority opinion. The dissent, the justices who disagree with the ruling explain why they disagree. So you don't only get I disagree in a dissent, it's a detailed legal analysis, just like the majority opinion, as to why the justice or the justices who disagreed do so. Typically, one justice writes a majority opinion and only one justice writes a dissent. The other justices join in either the opinion or the dissent. Despite the fact that the justices routinely disagree with each other, they never let it get personal and have good working relationship with one another. Both opinions and dissents become part of case law and precedent.
The Kalb Report is funded by a grant from the Ethics and Excellence in Journalism Foundation.
So that's also very important, right? That the dissent becomes part of case law and precedent. Even though it was not the winner, as Justice Ginsburg called it, it still becomes part of precedent. So it can be, you can go back to it at a later time. Also, very, very similar, incredibly similar to how halacha views dissent. What this means is that the future case at any level, lawyers can use the decisions and reasoning behind the case to help their own cases on any level of court. While opinions have a greater role in this because the majority of justices agree on it, dissents can also be used in future cases. Even though a case did not work out the way a justice believed it should, the arguments can be used in the future to potentially change the law and future rulings. And we heard her in her own words say that could happen two ways. It could happen through Congress, or it could happen on a future court. So she was very known for her dissents. She mentioned the civil rights. She mentioned Title VII, which is Title VII of the Civil Rights Act of 1964. Let's just see what it says. So, and what she was talking about. The Seventh Amendment to the Civil Rights Act of 1964, called Title VII, there's some discriminating against employees and job applicants based on race, color, religion, sex, and national origin. In the 1970s, Congress amended the act by passing the Pregnancy Discrimination Act of 1978, which clarified pregnancy discrimination as unlawful sex discrimination. Okay? And that's what she was referring to in that video that we saw, where the teachers were being dismissed with no guarantee to come back because they were pregnant, but that was not considered to be discrimination on the basis of sex. Okay. Here, we're going to listen to Justice Ginsburg on the famous Lilly Ledbetter case. She's going to explain what it is, but essentially it's a woman who was working at a company for decades, and then mysteriously finds out that she is being paid less than men in equal and even lower positions. This is a lengthier clip, but we're going to pick it up almost in the middle. At the 3:08 mark, where she starts to talk about this case specifically.
You became quite famous for your
Can you hear?
Oh, thanks. And in Lilly Ledbetter's case, every woman.
Yes.
Of a certain age knows what she experienced. That is, she was an area manager at a Goodrich tire plant. she, when she was hired, was the only woman area manager. One day, when she'd been working there over a dozen years, someone put a slip of paper in her mailbox. It had a series of numbers. The numbers were the salaries of all of the area managers. And Lily could see that the young man she had recently trained was earning more money than she was. So she said, enough, I'm going to sue. She got a substantial jury verdict, and then when her case came to the court, they said she sued too late. Title VII says you must complain within 180 days of the discriminatory incident. Lily Ledbetter is way out of time. She waited years to sue. My theory was that every time she got a paycheck, the paycheck incorporated the discrimination, so she could sue 180 days from any paycheck. I also pointed out that what would have happened had Lily Ledbetter sued early on. No doubt the defense would have been, it has nothing to do with Lily being a woman. She just doesn't do the job as well. But then she works there year after year and she gets good performance ratings. That defense is no longer available. They can't say she doesn't do the job as well as the men when they rated her as high or higher than the men. So now she has a winning case. But the court said she waited too long. So that kind of dissent, if the court is interpreting a statute like Title VII, then Congress can fix it. But when the court is making a ruling on a constitutional matter, Congress can't fix it. Only an amendment to the Constitution, and we have a Constitution that's powerfully hard to amend, or the court has to change its mind. But there has been a tradition in the United States of dissents becoming the law of the land. And we can go back to the worst decision the Supreme Court ever made. It was in the Dred Scott case. There was a fine dissent by Justice Curtis in that case. Or the first Justice, John Marshall Harlan, who dissented in the so-called civil rights cases in 1886 and in Plessy against Ferguson. Or you mentioned Holmes and Brandeis around the time of World War I. Those free speeches cases today are all the law of the land. So you're writing for a future age, and your hope is that with time, the court will see it the way you do.
Okay, so you see her point there is, hold on one second. So we see her point there is that sometimes you write for a future age, right? That's very telling. And that again is very much in keeping with the way that Judaism views dissent. So what I want to do now is I want to see Ruth Bader Ginsburg in her own words about dissent, and then we're going to look at some of the sources, the Jewish sources. So we have here, dissent speaks to the future, as she just said. It's not simply enough to say, my colleagues are wrong, and I would do it this way, but the greatest dissents do become court opinions. And gradually over time, their views become the dominant view. So that dissenters hope that they are writing not for today, but for tomorrow. It's actually a very powerful thing if you think about it, because it really speaks to judges' faith in the court and in the system and in the law itself, that they believe that they are right, but for technical reasons now, they can't, their view is not being taken, but they have faith that down the road, and sometimes it can take a very long time, they believe that down the road, they are going to win the day. And so they stay in the system and they write their dissent in the hope that eventually it will become law. So here we have a few other items from Ruth Bader Ginsburg on dissent. I'll just read a couple of the sentences before we move on to the Jewish sources. She notes here on the utility of dissenting opinions. I will mention first their in-house impact. My experience teaches that there is nothing better than an impressive dissent to lead the author of the majority opinion to refine and clarify her initial calculation. That's also really very important, right? In Judaism, we have this notion of chavruta, right? We always try to learn with somebody else. And the reason why we try to learn with somebody else is we sharpen each other. The two study partners sharpen each other, right? So that I may say something, but someone else is listening to it. To me, it sounds perfectly logical and legitimate, but someone else is listening to it, and they offer a counter to what I'm saying, and it forces me to sharpen my own ability to make my arguments. And then, of course, she goes on to talk about that it could propel legislative change or legal change. Okay, I want to stop for a second now and just see if there are any questions or comments along the way. Anyone have anything to add or anything to ask before we go on? I'm looking to see if there's anything in the chat. No. Okay, great. So let's talk about dissent in halacha. The main source that talks about dissent in halacha is a Mishnah in Masechet Eduyot. Lynn, can you see the screen and the source on the screen? Just want to make sure everyone could see it. Yeah. Okay. Great. So the source asks the question that we've been talking about the whole time. Lama mazkirin divrei hayachid ben hamirubin. We know that in a Jewish court we follow the majority, and so the Mishnah is asking, why do we record the opinion of the single person among the many, the minority amongst the majority? Hoil ve'ein halacha ela kedivrei hamirubin. After all, right? The halacha follows the majority. So again, who cares about the losing case? And so then the Mishnah answers its own question. She'im yir'eh beit din et divrei hayachid v'yismoch alav, she'ein beit din yachol levatel divrei beit din chavero ad she'yeh gadol mimenu b'chachma u'v'minyan. So that if a court prefers the opinion of the single person, it may depend on him. For no court may set aside the decision of another court unless it is greater than it in wisdom and in number. So there's two ways to understand what's going on here. The most straightforward way is that the majority in the particular case that's going on is going to rule like the majority. But another court may decide according to the minority view. And then in that case, as we learned in an earlier source in American law, and similarly in halacha, that dissent becomes precedent and part of the court record, and it's not so easy then to argue against it. So that's why the Mishnah says it's very important that the minority opinion be mentioned along with the majority opinion. And this may sound familiar because this is really precisely what Justice Ginsburg said. Okay, so let's read a little bit about how this is understood. This is from a wonderful article in a Jubilee volume in honor of Rabbi Saul Berman. And it's all about minority opinions. And the author, Rabbi Nadi Helfgott, makes a couple of important points. Maimonides himself, in a comment in his introduction to the commentary on the Mishnah, adds another dimension to his understanding of the Mishnah that we just studied. He refers to the Mishnah in Eidut and says, however, the reason it was necessary to record both the position of the minority and the majority is because it is possible that the halacha should be in accord with the minority view. And thus it comes to teach us that if the logic of the minority view is correct and clear, one listens to his opinion even though the majority take issue with him. Because what Maimonides is fighting against here is the notion that majority means correctness, right? And that's what Ruth Bader Ginsburg says, was fighting against for much of her career. And that's what the halacha is saying. Maimonides here seems to take the import of the Mishnah and Eiduyot to be highlighting an obvious but important point. Halachic truth is not determined by the majority. While ruling in favor of the majority is often a practical guideline that helps us in the practical realm, there is no guarantee that the majority has willy-nilly hit the mark in getting the decision right. Now, this may not have any practical, right? This may not have any practical application because at the end of the day, we have to follow someone. And how are you supposed to decide who to follow? So halacha said you follow the majority, but that doesn't mean that they are right. And that's why it's important to mention it, because at another time, the minority opinion, which may be right, will come back and be useful. So this is more of sort of a philosophical idea, that even though the rule is going to follow the majority, it doesn't mean that they are right. It means that for practical purposes, we have to rule in it. We need a rule as to how to rule, and we rule in accordance with the majority. Okay. Now we get to a more practical idea. More significant on the practical level are the readings of Rabbi Avraham ben David Paskier, the Raivan, and Rav Shimon of Sams. Both of these Rishonim understand the Mishnah in more radical terms. In their reading of the text, the Mishnah is teaching us that the existence and citation of the minority opinion indicates that the halachic system still views that position as a live option. Under normal circumstances, a later court cannot overturn or rule in contradiction to a previous court unless it is greater than in numbers and wisdom. However, if the second court is relying on an opinion listed in the Mishnah that is of minority status, it can overturn a ruling of the previous court, even if it is in inferior or a status in number and wisdom. That's a big deal, because it's very hard in halacha to overrule a court that is considered to be greater than the current one. But if the previous court had recorded a minority opinion, then that minority opinion can be used, and a lesser court could overrule a higher court. Now, this has wide-ranging ramifications in terms of how halacha is interpreted and how halachic decisions are made. Can a later authority disagree with an earlier authority? Can a younger authority disagree with an older authority? All of that those questions of whether that's possible or not come from how we understand this Mishnah. And according to these two authorities, we can understand this Mishnah in a very radical, wide way. Okay, so that's one way. That's one reason why minority dissenting opinions are important. They're important because they could be used later in future cases. There's another reason why minority opinions are important, and that is emergency situations. And I will tell you that since COVID started, we have been living, at least as far as halacha is concerned, in many situations, in what we call a shat hadachak, a time of pressing need. And so all of the changes that we've made to davening, if you were in shul on Rosh Hashanah and you notice all the things that we took out, and all of the way that the davening is shortened and it starts at a later time, and so many in terms of how we deal with so many areas of halacha that have to do with during COVID, it all is under this category of shat hadachak, an emergency moment, like a special time where the regular rules can't necessarily apply. And and in these cases, over and over again, we have turned to minority or singular opinions, and we've said, okay, we're going to have to rely on those singular opinions because we are in a time of pressing need. It's an emergency, and at least we have a single minority view that we can rely on, and that's what we have here on this slide. The first mention of this principle, meaning that we could rely on single individuals in case of emergencies, can be found in Tosefta of Ediyot, and possibly the parallel Mishnah, which we saw. The Tosefta, which is sort of a rabbinic statement of equal vintage, states, the halacha is always in accord with the majority view. The views of the minority were only mentioned among the views of the majority in case there may arise a time when there is a need to rely upon them. And the text of the parallel Mishnah is less clear. Why do we mention the individual opinion alongside the majority? We saw that the halacha follows the majority, that the court may, in the future, approve the position of the minority and rely on it, etc. So it's actually a really perfect time for us to talk about this, because many of the things that we have done in UOS and in so many of other shuls have been based on this idea of relying on minority opinions, because we are in a shat hadachak. We are in a situation of pressing need. Okay. From these Tanaitic and Amoraic sources, it thus emerges that it's permissible to rely upon a minority view in extreme circumstances, though halacha has formally been established according to the position of the majority. The Tosefta and the Mishnah maintain that a subsequent Beit Din can rely upon a minority view to upend the stringent view ruling of a previous court. In the Bavli, however, the Talmud's limits the principle of Rabbi Shimon is great enough to rely upon in an extreme situation only where the halacha has not been stated explicitly. That's more of a technical thing we're not going to get into, how far we can go on relying on minority opinions, even in an emergency situation. But even Ruth Bader Ginsburg did not mention this, but the notion of relying on majority opinions in halacha, minority opinions in halacha, is helpful because we can use it to rule in emergency situations. Okay, I just want to look at one more Jewish source before we end with two really neat things from Justice Ginsburg herself. Let me ask you, we'll stop here for a question. Is unanimity good? Right? Think about the Supreme Court, think about a halachic Beit Din. Would you rather have unanimity or not? It seems that maybe we can make arguments for both. Let's hear. Anyone want to take a stab at that? Is unanimity a good thing or not? You could use the raise your hand, or you could actually raise your hand, or you could put something in the chat. Okay, Emily?
Well, unanimous decision kind of indicates that people are confident that they are making the right decision, assumedly.
You were unclear at the beginning. Say again.
If people make a unanimous decision, it gives the sense at least that they're all confident that they are making the right decision.
Okay, so a unanimous decision maybe is a confidence builder. Okay, excellent. Anyone else want to take a stab at this? Okay, Ellie.
I just want to ask, in halakha, who said you could rely on the minority? Like, did you all just decide that you're going
No,
to?
it's
Because times are tough, or is it written somewhere?
well, we have the Mishnah that says we hold it as precedent, and then the commentaries on the Mishnah, and also there's a Gemara that says you rely on certain people in certain times in the Shat HaDachak, individual individual ruling. So it stems from the Gemara.
I just think it sounds sort of like contradictory. I mean, on the one hand, you would think that you have to have some ruling, so therefore you would have to go with the majority because that makes sense, doesn't it? Most people that want it. On the other hand, you can fall back on that one person that was brave enough to keep on putting another opinion forward that wasn't popular. I don't know how, it doesn't.
Yeah, I mean, to me, that's the beauty of the system in the sense that we learned already that that being the majority doesn't necessarily mean that you're right, but we just need some sort of rule to decide how to go forward. Otherwise, we'd be paralyzed. We wouldn't be able to make any rules. So the fact that being the majority doesn't mean that you're right opens up the possibility to use a minority opinion in an emergency when life couldn't go on in accordance with the majority opinion. It just was, it's too difficult. It's too hard. So this speaks to the incredible sort of flexibility of halakha, that even though, yes, majority rule is an important principle, it doesn't mean that that person's right. And therefore, really what it tells us, which is another paradox of halakha, is that opposing positions can both be right.
Well, I don't think majority has ever really meant to mean we're right, because we can never know that. It just means the majority of us think it should be this way.
Right, correct. And if it didn't
Inherent
mean
in that
that
has ever been, oh, therefore it makes it right.
Correct, that's true. It's good that you had that impression, because the other impression would leave us really stuck.
Yes.
What to do in an emergency. And by the way, this is not only an emergency, right? This is not only this doesn't only work in a communal emergency. This could work. There could be a ruling for most people, but another individual is in a unique circumstance. All sorts of different circumstances that would make their situation unique. And a rabbi then has at his disposal other opinions which normally would not be followed, but they're on the books and available to help that particular person in that particular situation. And rabbis do that all the time, right? And most people don't know about it because those are private conversations between the rabbi and the congregant or the student. So it's not only on sort of big communal issues like we've been talking about, even on private issues. So that the existence of minority opinions is incredibly important.
And that's quite empowering too, if you're ever in a position where you want to, not fold in if you feel strongly or passionate about something. That's quite empowering to say, keep your own principles, keep your own counsel, and just, speak it and then let it go. But have it documented if you're in that.
Yeah, and not only that, it's also very important for the person who's receiving the ruling, because I think it's an important goal to give as many people the understanding that they are within the realm, they are living in the realm of halakha, in the framework of halakha. So for the most part, in most situations, in the framework of halakha means the majority view. But for someone who can't do that, to be able to offer them and say, look, I understand you can't do that, maybe not yet, maybe not ever. So until then, try this on for size. It's not the majority opinion, it's different, but you're definitely still within the framework of halakha. That's empowering to the person, because now they still feel they're in, and they won't perhaps give up on the whole project. It's another very important reason. Okay. So unanimity, just one interesting thing that folks may have not been aware of. When it comes to capital cases, unanimity is bad. Amar Rav Kahana, this is the Gemara Masechet Sanhedrin. Amar Rav Kahana, Sanhedri shera'ui kulan lechova potrin oto. If there's a capital case and every member of the court of the Sanhedrin convicts the defendant, then they acquit him. automatically acquitted. A unanimous jury in capital cases is automatically acquitted. And the Gemara asks why. My time, what's the reason for this? Kevan de Gemiri halanat din l'ma'abed le zechuta v'hani tu lo chazile. What's the reason? Because there's another halacha when it comes to capital cases. It is learned in a tradition the suspension of the trial overnight is necessary in order to create a possibility of acquittal. Meaning the judges come to a ruling and then they have to literally sleep on it. And then only the next morning does the ruling become official. But if everyone, before they left for the night, has agreed guilty, then no one's going to be mulling any of the opposing arguments over in their mind at night, because there are no opposing arguments. And therefore, the whole purpose for delaying it overnight has been defeated. So it's a mistrial. It's over. The halacha is that they may not issue a guilty verdict on the same day the evidence was heard, as perhaps over the course of the night, one of the judges will think of a reason to acquit the defendant. And as those judges all saw fit to convict him, they will not see any further possibility to acquit him, because there will not be anyone arguing for such a verdict. Consequently, he cannot be convicted. So unanimity is not always good. Unanimity, in this case, it's good for the defendant, of course, but in terms of unanimity is not something that is always right in the courts, and that is what the Rambam says. Okay, so before I go on, there was a comment here from Nancy. I don't fully understand. So Nancy, do you want to unmute and just explain to me what you're looking for? Yeah, go ahead. Oh, no, we can't hear you. I don't know why. Can't hear you, Nancy. Okay, we'll try to get back to you if you could unmute yourself. Okay, so in her own words, I thank Lily Gelman for sharing this quote with me. I am a judge, born, raised, and proud of being Jewish. The demand for justice, for peace, and for enlightenment runs through the entirety of Jewish history and Jewish tradition. I hope in all the years I have the good fortune to continue serving on the bench of the Supreme Court of the United States, I'll have the strength and courage to remain steadfast in the service of that demand. So we see there a little bit of how she views herself in the trajectory, if you will, of Jewish judges, and how that has affected her. Okay, yeah, so Lynn, you're right. She wrote, I believe the minority opinion can actually increase understanding and acceptance of a majority opinion. For sure, it sharpens. Yeah,
Well,
absolutely.
also, like when you look at Supreme Court decisions, I think they represent two things. I'm going to use a word that may or may not fit, but like the zeitgeist, it's sort of like where society is and where minds are and opinions are at the time a decision is made. And court opinions tend to be very narrowly tailored, which allow room for subsequent appeals or other cases to be brought where they just look at a component of the ruling. They don't go to change the whole thing. They look at a component.
Mm-hmm.
And they look back at the precedent. And in the precedent, they'll also go back and look at that minority ruling. So it, as the other RBG said, it does lay the foundation and the groundwork for someone to use moving forward. But
right,
also
that's a very good point.
For the people who are hearing the opinion of a Supreme Court decision, you want to know how the minds wrestled with the information. If someone were just to lay out a dictate for you, it would be hard to accept. But if you could hear both arguments, which are usually extremely well articulated by Supreme Court justices, it's easier for you to then wrestle and sort through it in your own mind and at least understand how it got there. I think it really is a whole lot easier to accept when you hear both sides rather than just have it mandate.
Right, true, great, excellent, thank you. before we look at the last source, I am going. Yeah, go ahead, Nancy.
I wanted to go back to the previous comment about how you can't convict someone. You were saying what happens if they sleep on it and the next morning they all still agree for conviction?
As long as they didn't all leave. No, it doesn't matter.
So you never.
Correct. You can never convict on a unanimous verdict on a capital case. Okay, I'm going to show you a clip of an incredible video now about Ruth Bader Ginsburg in a minute and a half, a little more than a minute and a half, sort of summing up her life and why she feels so fortunate. This is not really about the class, but it was just so fascinating in terms of how she looked at her life, and totally something I would never have thought of. After that, I'm going to share the link of this presentation in the chat. So you can go back if you'd like to and look at all the videos and the source material if you want to take a chance to see it again. So don't, if you're interested in that, don't jump off just yet, okay? So here is Ruth Bader Ginsburg in her own words on looking at the bright side of life.
Do you have any regrets?
I
Do you have any regrets?
I do think that I was born under a very bright star, because you think of my life. I got out of law school. I have top grades. No law firm in the city of New York will hire me. I end up teaching. As I said before, they gave me time to devote to the movement for evening out the rights of women and men. I was not nominated to a vacancy on the Second Circuit. Instead, I was nominated to a vacancy on the DC Circuit. Much better place for me to be, because the DC Circuit decides a lot of very important questions involving what's going on in our government. So I'll tell you what Justice O'Connor once said to me. She said, suppose we had come of age at a time when women lawyers were welcome at the bar. You know what? Today we would be retired partners from some large law firm. But because that route was not open to us, we had to find another way, and we both end up on the United States Supreme Court.
Okay, I thought that was just exceptional, and really, really cool that she was able to just look back at her life, where she was the subject of so much discrimination and fought so many hard battles that ultimately, but she was able to just package it and like she said, say that she was born under a bright star. I thought that was really, really something else. Okay, so I am going to share this presentation now, share the link of this presentation with everyone. If you'd like to view it again, here it comes. Hold on one second. Okay, putting it in the chat now to everyone. Let's see, here we go. Everyone in meeting. Okay, There you go. You should all have that link now. You could copy and paste it into your browser or just click on it and you'll be able to open up the presentation. Thank you all for joining. It was really great for me to prepare this material and to learn more about this incredible woman. I learned more about her in the past year and a half. There was a film about her and a great documentary about her, both of which I watched. And you know, this looking at the similarities and differences in terms of dissent, of how she looked at it and how Jewish law looks at it and where it could be used, was I think a nice thing, a nice way to offer a tribute to her memory. So much of the life that certainly my generation takes for granted has her fingerprints on it. And so it was worthy to do this tribute. So thank you for joining, everyone. I wish you all well. I hope to see you soon, maybe at shul, maybe at another Zoom thing, maybe in my dreams. Until then, have a good evening, and thank you for joining. Good night, everybody.
Right.